So that we can keep it like class. Okay.
Council, this matter is for ruling. However, my attention has been drawn to additional authorities filed by the council for the applicant. So I don't know, Mr. Udo, have you been served with that additional authorities?
Yes, my lord, we have.
So I have not been able to go through them. In the
Yes, my lord, I looked through the authority.
Yes.
I have no need, my lord, to rejoin.
It's all right. What I'm saying is I'm just seeing it. My attention was drawn to it. I was not aware that it has been filed until now. So in the circumstance, I need time to look at it before I finally deliver my ruling. So I will adjourn to Friday, 19th, to enable me consider these authorities. This case is adjourned,
my lord.
19th of December 2025 for ruling.
My lord, I'm very sorry. My lord, I'm having burial of my very close relation on Friday. My lord, we could have done it to Monday.
Okay, Monday. What is Monday?
Monday is 22nd day of December, sir.
Mr. Obuji, is Monday 22nd okay for you?
My lord is convenient for me.
Okay, so it will be virtual like today.
Yes, my lord.
This case is 22nd December 2025 for ruling.
As God pleases. We are grateful, sir.
You are welcome. Register, call the next case.
Yes, my lord. Number NICN TA 48/2022 between Betty Tambam Ekuri and one Auditor General for Local Government, Cross River State, to Cross River State Universal Basic Education Board. My lord, the parties are absent.
Yes, you know the
Parties absent.
Parties are absent.
Okay. Appearance. Appearance.
Please, this honorable court.
Yes. Yes.
T.O. Inyambe.
T.O. Inyambe.
My humble appearance is for the defendants, my lord.
Any other appearance? Any other appearance? Yes, this matter is for judgment. The judgment is ready to be read shortly.
Thank you, my lord.
Yes, you are welcome.
Take it away. Then the second. But you come on this. Not that. And those who say they are fine.
Yeah, this is the judgment of the court.
So
on
they
the
receive it.
on the 18th day of, please, we need no, there should be no noise, please. On the 18th day of October 2020. Coming. On the 18th day of October 2022, the claimant took out a general form of complaint at the National Industrial Code of Nigeria. The general form of complaint was accompanied by a statement of facts, witness statement on oath, list of witnesses, list of documents, and photocopies of documents to be relied on at the trial. While this suit was pending before the court, the claimant name was restored back to the payroll of the dependent. This necessitated amendment of the statement of facts and witness statement on oath. By the amended statement of facts, dated the 18th day of April 2024, and filed on the same day, the claimant claim against the dependent as follows. A, the sum of 590,721 naira 1 kobo, being the salaries for March 2021 to December 2022 at the rate of 59,072 naira and 11 kobo per month. B, the sum of 2,244,740 naira 18 kobo, B, only being unpaid salaries for the months of January 2022 to September 2023 at the rate of 98,723 naira 50 kobo. After grade level 12 salary scale was implemented. C, the sum of 10 million naira as exemplary damages against the dependent for the loss of income and wrongful removal from the payroll voucher. D, an order bringing the claimant at par with his colleagues who are now on grade level 13 in line with the civil service rules. E, the sum of 1 million naira as cost for instituting of this action. The claimant on the 11th day of March 2025 testified in proof of his case as CW1. In the course of giving evidence in chief, 10 documents were tendered in evidence and they were all admitted without objection. They were all admitted in evidence and marked as exhibit CW1A to CW1J. At the end of his evidence in chief, CW1 was cross-examined by counsel for the defendant. In the absence of re-examination, the claimant was discharged. When the counsel for the defendant was called upon for the defense, counsel informed the court that the defendant are not going to file any defense as they would be relying on the case of the claimant. Consequently, parties were ordered to file their final written addresses beginning with the claimant. The matter was then adjourned to 22nd day of May 2022 for adoption of final written addresses. On the 22nd day of May 2025, T.O. Inyambe Esquire counsel appearing for the defendant informed the court that he is a receipt of the claimant's final written address. Counsel then asked for an adjournment to enable him to file his final written address. The case was adjourned to 15th day of July 2025 for adoption of final written address. However, court did not sit on the 15th day of July 2025, and the matter was again adjourned to 30th day of October 2025 for adoption. On the 30th day of October 2025, when this matter came up for adoption of final written addresses, the defendants and their counsel were not in court and did not file any final written address. The claimant adopted his own final written address, and the case was adjourned to today for judgment. The case of the claimant. A resume of the facts that led to the filing of this case are that the claimant was on the 25th day of March 2002 employed as a classroom primary school teacher on salary grade level 7, step 1. He rose to become master grade 3, salary grade level 12, C exhibit C1, CW1A, and CW1B respectively. The claimant stated that he has faithfully and diligently serve and perform his obligation until sometimes in August 2020, when he was offered a political appointment as a personal assistant to the deputy leader at Tonk Legislative Council, which he promptly rejected. However, in March 2021, the first defendant ordered the removal of the claimant's name from the payroll on the ground that he was holding a political appointment without resigning from his civil service job, thus earning double salary. The allegation of which the claimant stated was completely unfounded. The claimant made several remonstrations to the defendant to restore his name back to the payroll without success. It was after filing of this suit that the defendant decided to restore his name back to the payroll with effect from October 2023 without clearing the arrears of salaries owed the claimant and bringing him at par with his colleagues who are now on grade level 13. The claimant amended his statement of fact to limit his claim to period from when his name was removed from payroll to the time when his name was restored back to the payroll. Claimant's evidence under cross-examination. Under cross-examination, the claimant testified that it was correct that it was alleged that he was collecting salary from two sources. He also stated that he was not told that Subed and his local government forwarded his name to the payroll. He did not forward or reject the rejection of appointment by the local government or anybody or person. He cannot remember last date of his promotion. Exhibit CW1B is the last letter of promotion. I cannot remember the exact date in March when they said my name was removed from the payroll. I can't remember receiving salary for January 2022. My name was removed from payroll in March 2021. I cannot remember the date of the said removal. The submissions of the claimant. Mr. M.A. Ekong, Esquire Counsel for the claimant, adopted his final written address as his argument. In the written address, twin issues were formulated for determination. They are whether or not the claimant has a proper course of action against the defendant before his honorable court. 2, whether the claimant has proven his case against the defendant to be entitled to relief sought. In arguing issue 1, counsel for the claimant submitted that the claimant in this case has disclosed a proper course of action which can involve jurisdiction of this court. To support his submission, counsel relied on the case of Sahim versus Government of Lagos State, where the Court of Appeal held as follows that the statement of claim of a plaintiff must disclose a course of action, set out the legal right of the plaintiff and the obligation of the defendant. It must also go on to set out the facts containing the infractions of the plaintiff's legal rights or failure of the defendant to fulfill its obligation. Counsel contended that the claimant has fulfilled its obligation and asked the court to so forth. On issue 2, counsel answered the said issue in the affirmative. Counsel asked the court to enter judgment for the claimant against the defendant because on the totality of the evidence before this court, the claimant has proved that there is an existing employment relationship between him and the defendant and that the claimant's salary was unjustifiably stopped. The defendant admitted this much when they instated the claimant to the payroll during the pendency of this suit, but failed to clear the arrears of salary. More so, the defendants having failed to file the defense to this suit have admitted all the abandonment of the claimant in his statement of fact. In Oladipo versus Moba local government, it was held that where no statement of defense is filed in answer to the statement of claim by the ordinary rules of pleading, the abandonment in the statement of the abandonment in the pleadings in the statement of claim are deemed to have been admitted, are taken to have been admitted. The natural consequences of default in filing statement of defense is that the allegation in the statement of claim stand unchallenged. In the circumstance, counsel asked the court to hold to hold to hold to so hold and enter judgment in favor of the claimant. In concluding his submission, counsel submitted that from the totality of the evidence adduced during the trial by the claimant, it is evident that the claimant has firmly established his employment relationship with the defendant and ought to enjoy his salaries uninterrupted in exchange of his service. In Ogbedu versus 80, the Supreme Court held that the relationship between employer and employee is regulated by the service agreement or the condition of service. It follows that the only document which shows the employee's condition of service and which court is enjoined to examine to determine employee's entitlement is service agreement. In the instant case, the regulatory document in question is a letter of appointment issued to the claimant dated 25th day of March 2022, which was tendered 2002, which was tendered in evidence without objection by the defendant. The exhibit spells out the fact that the claimant is entitled to his salary in exchange for his service. Any disruption of this payment amount to breach of contract. Counsel asked the court to so hold. Court's decision. I have carefully and painstakingly considered all the processes filed in this suit. As pointed out earlier in this judgment, the defendant who were represented by counsel at the trial chose only to cross-examine the claimant when he adopted his witness statement on oath as his evidence during examination in chief. The counsel for the defendant, when called upon by the court for the defense of the defendant, informed the court that they are relying on the case of the claimant. Let me say that the position taken by the defendant is not filing defense was profound in that it is risky and dangerous, as it was risky and dangerous stance that makes the defendant swim and sink together with the claimant as they agree to follow the claimant wherever he decides to carry them to. For whatever it is, the defendants resting their case on that of the claimant is taking a legal strategy that is allowed by the law for a party to take, wishing to do so, and it cannot be taken as a mistake. However, when a defense counsel rests his case on that of the claimant, he is bound by that decision. And the implication is that the claimant has not made out any case for the defendant to answer, or that the defendant admits the facts of the case as presented by the plaintiff, or that he may be saying that the defendant has a complete answer in law to the claimant's case. Once a defense counsel makes that announcement, he is resting his case on that of the claimant, as was done in this case. He must stand by his submission. See the case of Atugbos versus Chime and that of Akambi versus Alao. See also of Pomaja versus Commissioner for Education. In the instant case, the counsel for the defendants who participated in the proceedings before the court failed and neglected to file final written address for the court to appreciate the philosophy behind the stance taken in not filing any defense. For whatever it is, the refusal to file defense is a clear indication that the defendant do not have contrary facts to put forward before the court, apart from those they were able to extract from the claimant under cross-examination. The defendant are therefore deemed to have admitted all the facts about in the pleadings of the claimant. However, I shall quickly point out that the mere fact that a case is not dependent does not entitle the court to overlook the need to ascertain whether the evidence adduced before it establish or prove the claim or not. This means the court is not for any reason relieved of the burden of ensuring that the evidence adduced in support of a case sustain it, irrespective of the posture of the defendant. Apart from ensuring that the evidence laid support the case of the claimant, and this the court must do, it is only bound to make finding of facts on issues joined between the parties. See the case of Oyewole versus Oyekola. In civil cases, the onus of proving a particular fact is on a party who asserts, and because civil cases are determined on balance of probability and preponderance of evidence, a party who has laid credible evidence to prove his case will obtain judgment based on such preponderance of evidence and balance of probability in his favor. See the case of New Breed Organization versus Eremosele. See also the case of Elias versus Omobare and that of Arashe versus Arashe. The law remains that where the defendant fails to adduce evidence to counter or challenge the evidence of the claimant, the burden of proof on the claimant is minimal. In the instant case, the main evidence before the court was that the claimant's name was removed from payroll on the ground that he was offered political appointment to serve as legislative aide to Deputy Speaker of Etum local government area of Cross River State. However, the claimant stated that though he was offered political appointment, he promptly rejected it and continued with his service to the defendant as primary school teacher. He also protested that his removal of his name from the payroll as ordered by the first defendant. He tendered in evidence of the CW1J bank statement of account to prove that he was not receiving double salary as alleged. The defendant did not deny the claim of the claimant that his name was removed from payroll as from March 2021 until October 2023 when he was restored. The defendant did not also deny or dispute the fact that non-payment of claimant salaries from March 2021 to October 2023. This goes to show that the claimant's name was removed from payroll from March 2021 and it was only restored as from October 2023. The claimant was also not paid his arrears of unpaid salaries by the defendant after restoration of his name. The defendants did not also dispute the claimant's claim that even when his name was removed from the payroll, he continued to serve the defendant by carrying out his teaching assignment. Therefore, the evidence of the claimant which had not been contradicted under cross-examination is, to my mind, sufficient to prove claimant's claim on salary. The claimant has discharged the onus on him of minimal proof. I note in Relief A, the claimant's claim is for the sum of 590,721 naira 1 kobo. These are salaries from March 2021 to December 2021 at the rate of 59,072 naira and 11 kobo. This relief succeed and it is hereby granted. The reason being that in Exhibit CW1J on 9th of March 2021, the claimant was paid this sum of 59,072 kobo and 11 naira as his salary for the month of February 2021. And this is the last salary paid before removal of claimant before removal of the name of the claimant from the payroll of the defendant. On Relief B, claimant is claiming for the sum of 2,244,740.18 kobo as unpaid salaries for the months of January 2022 to September 2023 at the monthly rate of 98,723 naira 50 kobo. This was after his grade level 12 salary scale was implemented. What is baffling about this relief is that there is no evidence adduced before the court showing that after the payment of February salary to the claimant on the 9th day of March 2021 in the sum of 59,072 naira 11 kobo, there was, as shown by Exhibit CW1J, there was an increment or increase or review of the claimant's salary from 59,072 to the sum of 98,723 naira 50 kobo, based on which the claimant is now claiming unpaid salaries from January 2022 to October 20 to September 2023. Based on a calculation made at the sum of 98,723 naira 50 kobo. This amount was not the last salary that was paid to the claimant. As I pointed out, it is only the last salary of the claimant that he can use to claim all his entitlement, unless he is able to prove to the court that there has been an increment, and there was no such proof before the court. In the absence of evidence that claimant's salary had been increased, this court is duty bound to stick to the last salary of the claimant as the basis for computation of the salary he is entitled to from January 2022 to September 2023, which is a period of 21 months. To arrive at the correct computation, the sum of 59,072 naira 11 kobo will be multiplied by 21. If multiplied by 21 months, which was the period covered, the claimant will be entitled to the sum of 1,240,514 naira 31 kobo. In the circumstances, the claimant's unpaid salaries for the period of January 2022 to September 2023 is the sum of 1.2 million and not 2.2 million as claimed. In the circumstances, relief B succeed partially. Relief C is for the sum of 10 million naira as exemplary damages against the dependent for loss of income and a wrongful removal from payment voucher. In law, exemplary damages, also known as punitive damages, are fundamentally different from general and aggravated damages because their purpose is not to compensate the claimant. Instead, they are awarded to punish the dependent for outrageous conduct and to deter the dependent and others from similar conduct in future. They are punitive and determined in nature, serving as a mark of court disapproval of the dependent action. The Supreme Court, in the case of GKF Investment Nigeria Limited versus Nitel PLC, has outlined the categories of damages, distinguishing exemplary damages as punitive. See also Williams versus Daily Times of Nigeria Limited and Udofel Limited and another versus Sky Bank of Nigeria PLC, which further elaborated on the exemplary damages which are awarded where the dependent conduct is oppressive, arbitrary, and unconstitutional, or where the dependent's conduct was calculated to make a profit that might exceed the compensation payable to the claimant. See the case of GTV PLC versus Imanaga. The dependent's removal of claimants in view of the evidence before the court and also the evidence of the claimant under cross-examination that he did not forward his letter of rejection of his political appointment. Can it be said that the dependent's removal of the claimant's name from the payrolls Can the conduct of the claimant in removal the names of the claimant from payroll be said to be outrageous, or to be said to be illegal or unconstitutional? I think it is reasonable when there is reason to believe somebody is another employment to stop his salary so as to prevent him from getting double salary. The dependents in this circumstance cannot be said to have acted without justification in stopping the claimant's salary. In the circumstances, relief C claiming exemplary damages fail, and same is hereby refused. I now turn to relief D, which is for an order bringing the claimant at par with his colleagues who are now on grade level 13 in line with the civil service rules. The claimant by relief D is asking for the court to order the defendant to bring him at par with his colleagues who are on grade level 13. In other words, the claimant wants the court to make an order for him to be promoted to grade level 13, the grade level on which his colleagues are now on. By the decision of the Court of Appeal, by the decision in the case of Abengu versus Benue State Civil Service Commission, it was held that promotion of employee is neither automatic nor is it a right. This means that promotion is a privilege and not a right, which a party can claim without proving his entitlement to it. As such, court will not grant such a relief. See also the case of Shell Petroleum Development and others versus EN Nwaka and another. In the case of Umoye versus FAN, Federal Airport Authority of Nigeria, the Supreme Court made it clear that promotion from one grade level or position is in an organization to another is not a right, but a privilege which is earned. An employer cannot be compelled to promote its employee, no matter the good opinion of the employee might have of himself. The implication of the above decision is that the court will not grant relief of promotion unless there is evidence establishing that the refusal of promotion was vindictive, malicious, or in bad faith, and that the employer also is entitled to such he has earned that promotion. In the case at hand, the claimant has not adduced any evidence to prove how he became entitled to promotion to grade level 13. He said he made mention of civil service rules, and he never cited or made reference to any provision of the civil service rules that entitled him to such promotion. He has also not shown that he has fulfilled and satisfied all the conditions for promotion, but was willfully denied by the defendant. In the circumstances, the relief did fail due to lack of proof, and same is hereby refused. I now move to relief E, which is for the sum of 1 million naira as cost for instituting this action. In law, cost a law post follows event and is granted at the discretion of the court to a successful party. However, the claimant has specified the quantum of amount he is claiming for as cost. This has made the claim to be for special damages, which by law he has this. The claimant has to specially plead it, particularize it, and strictly prove it. The claimant has not tendered any evidence in proof of the said 1 million naira, which is said to be the cost of the action. In the circumstances, this relief E fail, and same is hereby refused for lack of proof. On the whole, the claimant succeed as found by the court above. For avoidance of doubt, the court order is as follows. 1. Relief A succeed, same is hereby granted. The defendant are hereby ordered to pay the claimant the sum of 590,721 naira 1 kobo being claimant salaries from March 2021 to December 2021. To December 2021 at the rate of 59,072 naira 11 kobo. Relief V also succeed in part in that, to the extent that the monthly salaries are calculated based on the last paid salary to the claimant as per Exhibit CW1J, i.e. 59,072 naira 11 kobo. If this amount is multiplied by 21 months, the total sum the claimant will be entitled to will be the sum of 1,240,515 naira 31 kobo. This amount is hereby accordingly granted. Relief C failed. Same is hereby refused and dismissed. Relief D also cannot be granted as it has not been, as the claimant has not established his entitlement to receive relief. Therefore, relief D is hereby refused for lack of proof, and same is hereby also dismissed. Relief E is equally not grantable due to lack of proof, as same is hereby refused. However, all monetary reliefs granted as per this judgment shall be settled within 30 days from today, failing which 10% interest per annum shall apply to the final liquidation. Judgment is hereby entered accordingly.
As the court.
As the court pleases. We are grateful, my Lord, for this judgment.
You are welcome.
Jesus.
Registrar, call the next case.
Yes, my lord. Suit number NICN CA31-2025 between Mrs. Glory Umar and African Alliance Insurance PLC. My lord, the parties are absent.
Appearance.
With respect, the Lord, Mercy Abatekaneko. My Lord, appearing with me are Rosemary Attorney Ukam and Ebeneza Ugbe.
You say you are appearing with who?
Please for the claimants.
You are appearing with who?
My Lord, we are appearing with Rosemary Anthony Ukam.
Rosemary
Anthony Ukam.
Anthony Ukam.
Ebeneza Ugbe. My Lord.
Ebeneza who?
Ugbe is spelled UGBE. Claimant.
Ugbe. Oh.
We apologize for our absence. For the claimant, my Lord.
It's all right. Any appearance for the defendant?
My Lord, the defendant has never put on appearance in this matter.
Okay, this matter is for judgment. The judgment is ready to be read shortly. Yes, this is the judgment of the court. by the originating summons dated 17th day of June 2025 and filed on the same date, the claimant submitted twin questions for resolution. They are: one, whether the failure of the defendant to pay claimant her monthly pension from May 2024 till date is a fundamental breach of contract of service signed between the claimant and the dependent on 20th day of December 2018. Two, whether the failure of the defendant to pay the claimant the sum of 30,354 naira 93 naira through her Zenith Bank account number 10010945573. Same representing her monthly pension from May 2024 through her Zenith Bank account PLC, as agreed, is a fundamental breach of contract for which the claimant ought to be paid general damages. In anticipation of favorable consideration or resolution of the question submitted, the claimant seek for the following reliefs. They are: a declaration that the failure of the defendant to pay monthly pension to the claimant is a fundamental breach of contract term signed between the claimant and the defendant on the 20th day of December 2018, while entitles the claimant the sum of to repudiate the contract. B, an order of court mandating the defendant to credit claimant's Zenith Bank account number 10010094573 with the sum of 30,000 being pension owed her plus 50% interest on the sum held over by the defendant from May 2024 till the judgment sum is finally paid. C, an order of court mandating defendant to credit claimant's account with Zenith Bank with her balance in the claimant's retirement savings account. D, prejudgment interest on the sum claimed in three above at the rate of 20% from the first day of May till the date of judgment, and thereafter at the rate of 10%. E, the sum of 10 million naira only being general damages for the breach of contract. The originating summons is supported by a 13-paragraph affidavit sworn to by the claimant herself. Attached to the affidavit are 3 documents marked as Exhibit CW1, CW2, CW3. A written address accompanies the originating summons. Arguing in support of the summons, Mercy Abasekan submitted that for the claimant informed the court that he is relying on the position contained in the affidavit in support, as well as the 3 exhibits attached therein. Counsel also adopted the written address as his argument in this case. The facts forming the nucleus of the claimant's claim are that she is a retired civil servant and an annuitant with the defendant, holding pension account number PN 20034193044. That the defendant that on December 20th, 2018, the claimant and the defendant entered into contractual agreement Exhibit WC1 for the defendant to manage the claimant's pension fund and provide monthly pension payment for life. According to the claimant, the agreed monthly pension amount was 30,000 naira, 354 naira, to be paid to the claimant's Zenith Bank account. However, the defendant failed to pay the claimant her monthly pension from May 2024 to the present date. Contrary to the terms of agreement of the claimant's contrary to the terms of the agreement, the claimant's pension account was funded by deduction from her salaries for the period she served. The claimant, though through her lawyer, issued a demand notice letter to the defendant on December 6, 2024 for the unpaid monthly pension of the defendant, recorded via email on January 6, 2025, Exhibit C, WC3, citing internal problem as a reason for the However, despite being served with the originating process commencing this suit, the defendant has failed to appear or file any defense. In the written address adopted by counsel for the claimant, a single issue was formulated for determination to it whether the failure of defendant to pay claimant a monthly pension as per terms of contractual agreement is fundamental breach. In arguing the sole issue, counsel submitted that the claimant's retirement savings account with the defendant accrued as deductions from the claimant's salaries by employer. Over the years, the claimant was employed by Federal Minister of Defense and she retired after 35 years of meritorious service. Counsel submitted that the annuity agreement dated 20th day of December 2018, clearly spelled out the contractual relationship of the claimant and defendant. The duties of the defendant to the claimant is to ensure that the claimant monthly pension is paid before the end of 25th of every month. But the defendant has breached this duty and is still in breach owing the claimant pension in 2025. The duty of the court is to determine the right of the parties based on the ordinary construction of the agreement between them. The agreement also contains clauses giving the claimant the right to repudiate the contract where she is not satisfied with the conduct of the defendant. In support of this submission, counsel refers It is also the submission of counsel that Section 8 of the contractual agreement contains the duties of defendant, while Section 8.1 of the agreement dated 20th day of December enjoins the defendant to make monthly payment of the claimant. According to counsel, this obligation is fundamental duty which the defendant has breached. Thus, breach of fundamental duty entitled party to for as well as repudiate the contract. It is submitted that a fundamental breach fundamental term of contract was explained in the case of Niger Insurance versus Abed Brothers as a fundamental term of a contract is a stipulation which the parties have agreed Counsel also submitted that the defendant whose activities is being supervised by Actom versus NICOM has not just breached the agreement with the but also a fundamental duty enforced on it by to review regulations or retirement life annuity casual But it is also submission of counsel that by Section 9G, the defendant has a duty to manage and meet reasonable expectation of its customers, as the claimant has no other expectation than to be paid her pension, credited to her account not later than 25th day of every month. This the defendant has failed to comply with for almost 12 months now. It is settled principle of law that where there is wrong, there is remedy. Counsel on this counsel relied on Umedige and another versus Shell Petroleum. Where the Apex Court held that damages is pecuniary compensation, which is a law award to person for injury he sustained by reason of act of, or default of another, whether that act or default is breach of contract or tort. On this submission, counsel placed reliance on the case according to counsel. The claimant has shown that the defendant has not paid her pension from November 24 till date, and the court has a duty to grant such prayer. It is also submission of counsel that the claimant has the right to repudiate the contract. Counsel also submitted that Section 12 of the terms of agreement and dependent makes room for termination of contract. Section 12.2 provides that the retiree can terminate his contract where there is non-satisfactory performance. Upon reading of the account service etc. In concluding his submission, counsel asked the court to hold that the defendant breached a fundamental condition or terms, and the claimant is entitled to damages and also to repudiate the contract. Counsel urged the court to enter judgment for the claimant and grant her all her relief. Court decision. I have considered the originating processes and all the other processes accompanying them. The fact of this case, as can be gleaned from the processes filed, are straightforward. The claimant is retired civil servant and an annuitant with the defendant, pursuant to Exhibit CW1A, CW1 agreement between the parties made on 20th day of December 2018. The agreement exhibits the facts of this case is that, as can be gleaned from the pleading and evidence of the claimant is a retired civil servant and annuitant of the defendant, pursuant to an agreement as per WCC1. The agreement was for defendant to manage claimant's pension fund, provided monthly payments for life to the claimant. According to the claimant, the agreed monthly payment amount was 30,354 naira 93 kobo to be paid to the claimant's Zenith Bank account not later than 25th day of each month. However, the defendant defaulted and has failed to pay claimant for monthly pension from May 2024 to the present day, contrary to the terms of the agreement. The claimant's pension account was funded by deduction from claimant's salary for 35 years of service. While Exhibit 2, by the Exhibit 2, the claimant, through her lawyer, issued a demand letter to the defendant on December 6, 2024, Exhibit CW2 or WC2 for the unpaid salary monthly salary, a response to the letter of demand by the claimant through her solicitor. The defendant cited internal problem as the reason for the non-payment, which the claimant considered irrelevant to her contractual entitlement. See Exhibit WC3. By virtue of by rules of this court, originating summons is one of the modes of commencement of action, principally determine questions on interpretation of document, and there is no substantial dispute of fact. However, where facts are in dispute or gratuitously so, and originating summons is not the appropriate mode of commencement of an action. See the case of Inajoku versus Adeleke or Shubande versus Oyewumi. As pointed out earlier, the defendant in this case has failed or refused to file counter affidavit to the affidavit in support of the originating summons commencing this suit. The most critical consequences of not filing a counter affidavit is that all the facts stated in the claimant supporting affidavit are deemed to have been admitted. See the case of Ojo Male versus Yaduat and another, where the apex court unequivocally held that where the law requires court to use affidavit of the parties in proceeding commenced by originating summons in deciding issues submitted in the originating summons for resolution. See Umogu versus Imo State Independent Electoral Commission. Consequently, filing of counter affidavit such suit is very crucial as it serves as a primary mechanism for the factual assertion made by the claimant. Without a counter affidavit, the defendant effectively forfeits the opportunity to present the alternative factual summaries introduced Therefore, the court will proceed to determine the originating summons based on the unchallenged facts. While general rule is that unchallenged facts are admitted, it is important to distinguish from competence of the initial affidavit itself. The Court of Appeal in Anene versus Alabi and another clarifies that it might not be strictly necessary to file a counter affidavit where the initial affidavit is fundamentally incompetent. And an affidavit may be incompetent if it is an affidavit may be incompetent if it contains hearsay, legal argument, or conclusion instead of facts, or fail to comply with statutory requirements. If an affidavit supporting an originating summons is inherently defective or fails to meet such statutory prerequisites or the requirement of proof, the court may suo motu or upon application strike it out, even if no counter affidavit was filed. This means that the court retains its duty to apply the relevant laws to the admitted facts before it. The overall defendant's failure to file a counter affidavit severally weakens the defense and preclude the defendant from challenging the factual foundation of the claimant's case, which may I shall now consider whether by the two questions submitted by the claimant has proved entitlement to the relief being sought. The two questions falls for determination by this court clearly calls for consideration of XBCW1. The agreement for life annuity voluntarily entered into between the claimant and the defendant. I have perused XBCW1, which is subject matter of interpretation as per the question formulated by the claimant. It is in the interpretation of document, the apex court has this to say. In the case of Union Bank versus Ozigi, the word in document must first be given their simple and ordinary meaning, and under no circumstances may new or additional words be imported into the text unless the document would be, by the absence of that which is imported, impossible to understand. The presumption is that the parties have intended what they have in fact said so. Their words must be construed as what they have stated. See the case of Solicitor General of Western Nigeria versus Adebanjo. See also the case of Ghana versus SDP and others, and that of Omuahe versus Umoru. In the case of Bessie Oyube Atoy and another versus David Atoy and others, the Court of Appeal has enjoined adoption of broad, holistic, and all-encompassing approach. Exhibit C1 is the agreement for life annuity contract between the parties, and this document requires interpretation of clause 1.0 to 1.2, 2.2 to 2.2, 3.0 to 3.2, 4.0 to 4.1, 5.1, 5.1 and 60 to 62, as well as 8.1.0. The agreement under construction is for retiree life annuity. The agreement under consideration is for retiree for life annuity, which is one of the modes of accessing periodic pension payment under the continuity pension scheme. Under the Pension Reform Act, retiree life annuity is a stream of monthly, quarterly income purchased from an approved life insurance company, which with available retirement savings account balance of retiree as premium. It proves a guaranteed periodic income or pension to be paid to the retiree for life. However, if retiree dies before the expiration of 2 years from the date of commencement, the named beneficiary shall be paid pension benefit of the deceased for the named beneficiary. A holistic consideration of Exhibit 1 clearly shows that the claimant, in this case, who served the defendant, who served the federal government of Nigeria and retired from service, had entered into an agreement with the defendant to insure insurance firm for purchase of annuity, whereas the claimant, with effect from 13th January 2019, will be paid from the agreement entered into by the parties with effect from 13th January 2019, the claimant will be paid the sum of 120 naira, 23 naira, 17 kobo on monthly basis. The payment to the annuitant shall be through her account with Zenith Bank. It is clear from XBCW1 that it is the duty of the defendant Therefore, I resolve question 1 in favor of the claimant, as the defendant has abdicated his duty under the terms of the agreement by refusing to pay or stoppage of payment on monthly basis to the claimant. The defendant failure to pay the claimant as her monthly pension from May 2024 to date constitute a fundamental breach of the agreement for life annuity contract entered into between the parties. This is evidenced by clear terms of the agreement requiring monthly payment, which is a core obligation of the agreement of the parties. This position is supported by the fact that the defendant has admitted non-payment in Exhibit CW3, an email in response to demand by the claimant solicitor. The defendant's consistent failure to pay claimant as from May 2024 has directly impacted the claimant's livelihood negatively and has also defeated the very purpose of the annual agreement, which is to ensure a retiree gets steady income to be able to have a decent life after retirement. The defendant's failure to keep pace with the monthly payment to the defendant has also neglected the defendant failure to keep pace with the monthly payment of the claimant has also negated NICOM regulation and guidance on prompt and timely payment of annuity. On the quantum of money claimant is entitled to on monthly basis from May 2024 to 17th June 2025, which is a period of 13 months, 17 days. Going by clause 3.2 of XBCW1, the claimant is to be paid the sum of 123 naira 17 kobo as on monthly basis. If the paid amount payment is multiplied by 13 months, on the quantum of money claimant is entitled to on monthly basis from May 24 to 17th June 25, the period covered is 13 months, 17 days. Going by the clause 3.2 of Exhibit WC1, the claimant is to be paid the sum of 122 naira 17 kobo. If this amount is multiplied by 13 and 17 days, claimant unpaid monthly salary, unpaid monthly payment for the period of May 2024 17th June will be the sum of 1,605,300 naira. Having found that the dependent have violated the clear and unambiguous provisions of CW1, the agreement for life annuity contract, the questions are resolved in favor of the claimant against the dependent, while the question 2 is resolved in favor of the claimant only to the extent as found by the court. In view of the resolution of the 2 questions submitted by the claimant for resolution, I hereby grant reliefs as follows. 1. A declaration is hereby granted that the failure of the dependent to pay monthly pension to the claimant is a fundamental breach of agreement life annuity contract signed between the claimant and the dependent on 20th day of December 2018, which entitles the claimant the right to repudiate the contract. 2. Based on the sum of 123 naira 17 kobo being amount paid for monthly payment of the claimant as per XBCW1 agreement based on the sum of 123 naira 17 kobo being amount paid for monthly payment to the claimant as per WC1 agreement for annuity contract, which is to be paid into our account, the claimant will be entitled to the sum of 1,605 naira 17 kobo, being amount owed the claimant by the dependent. However, I refuse to grant the 30,000 naira claim by the claimant because that amount did not tally with the amount which the agreement provided should be paid. See Exhibit WC1. Or relief 3 is hereby refused due to lack of proof, as there is no proof of what is the outstanding balance due to the claimant in her account, no place of giving order. The relief on pre-judgment interest on the sum claim in 3 above at the rate of 20% is the date of judgment, and thereafter at the rate of 10% liquidated fails due to lack of proof. Relief on pre-judgment interest on the sum claim in date of judgment also fails due to lack of proof and is hereby refused. Relief, the claimant having shown that her monthly pension payment was withheld by the claimant and remain unpaid till date, is entitled to damages for the period the dependent refused to pay the claimant her entitlement as per Exhibit CW1. The claimant is hereby entitled to damages which I assess to be the sum of 500,000 naira. Cost.
Thank you very much.
In view also In view of breach of the terms as contained in Exhibit WC1, I hereby made a consequential order that the claimant, the defendant, shall immediately commence payment of the claimant monthly annuity. The defendant is hereby ordered to immediately resume payment to the claimant of her entitlement on cost of having succeeded. In fact, on cost, the claimant having succeeded, in fact, is entitled to costs which are assessed in the sum of 300,000 naira. This judgment takes immediate effect. Judgment is hereby entered accordingly.
As a court places. As a court places.
Yes.
We are grateful for the judgment.
You are welcome.
Hello, we thank you and we ask that God bless you. We wish
You are welcome.
you a very happy Christmas and the new year to come. Thank you, my Lord.
You are welcome. Registrar, any other?
No, my Lord, that's all for today.
Okay. You adjourn those of tomorrow. The next tomorrow.
Yes, my Lord. Next tomorrow.
Okay. Thank you very much.
Yes. Thank you, my Lord.
Okay.
Thank you.
We have
Thank
come
you.
to the end of this meeting.
Oh, we are finished. All right. We have got to take a course now. Another one. Okay. Thank you, sir. Let me make inquiry. Well done, sir. How about this?